How do you think the money laundering and tax fraud crimes that we've been hearing about recently, most recently we've heard about the Gupta brothers and Sanjay Shah, how do you think these will impact the UAE?
I will answer this question from a legal perspective and to the extent where it affects financial institutions and DNFPPs, or designated non-financial businesses and professions, because eventually the risk exposure of these persons being present in here relate mainly to their involvement in, as you said, fraud cases, and at the same time in AML crimes that could involve investigations that will allow authorities outside the UAE or different parties to communicate and coordinate with authorities in the UAE to take the appropriate measures in respect of these individuals. But going back to basics, these individuals pose a question, or the involvement or the relationship between these individuals and the jurisdiction of the UAE pose questions as to what extent the system in the UAE is strong enough to protect it from being exposed to these international crimes or cross-border crimes or crimes that have been committed outside of its boundaries and relate mainly to AML and tax fraud and so on and so forth. The UAE has been working aggressively for the past 4 years at least to improve their AML and sanctions legal framework. There have been so many changes to the AML legislations, including the UAE federal laws on anti-money laundering, counter-financing of terrorism and sanctions. A lot of authorities have been established lately to address specific aspects within the overall AML and sanctions framework. We have seen a new definition for what we call designated non-financial businesses. Obviously, banks and financial institutions were among the ones that have the heavy part of handling compliance with AML and sanctions and counter-financing of terrorism. But now we have seen more and more involvement of different authorities, including Ministry of Justice as far as notaries, lawyers, legal consultants are concerned. Also, the Ministry of Economy when it comes to certain businesses. And otherwise, but the importance of this is we're seeing like the creation of an overall ecosystem that addresses different risks associated with AML, counter financing of terrorism and sanctions as far as all of these are concerned. And among the major changes that took place lately, as we said, the introduction of new definition for DNFPPs, but also the interactive role that the central bank is taking, that the Ministry of Justice is taking, Ministry of Economy and other authorities in heavily supervising the implementation of AML regulations. When it comes to the individuals you've mentioned or to the cases that you've referred to, obviously the authorities will have to take immediate action to identify the involvement of these authorities in the jurisdiction. And based on their involvement, they can address what kind of measures can be taken to analyze or to implement in order to either mitigate the risks associated with these individuals or to address these risks accordingly. So obviously, as soon as these cases were known, we know for a fact that banks immediately carried out checks across their systems. There has been an overall reporting system where all parties that have an obligation to make such reporting were obliged to disclose information they hold on these individuals, including the assets they hold or what kind of funds they hold on their behalf. Yes. And based on that, the UAE authorities will take the appropriate action through the various bodies, including the public prosecution, central bank, courts, and so on and so forth, to address the situation accordingly.
Speaking of client screening, what do you think will be the major challenge in managing these data?
Obviously, we spoke about like the creation of many authorities in the UAE in the past 2 years to address certain aspects of the AML process or the screening process. A new body was created, which is called the Executive Office for Control and Non-Proliferation, and this is one of the main authorities that was created to address sanctions in terms of handling the local sanctions lists and also giving access to the UN sanctions lists. So banks, financial institutions, designated non-financial businesses and professions, including auditors and legal consultants, are now required to keep to be updated as to, or to keep a registration or some form of a listing with this authority, whereby they receive regular input or regular updates on any new additions to the local sanctions lists or to the UN sanctions lists. And this will ensure that all of these parties that we've mentioned have updated checks on their systems and will allow them to identify any exposure to sanctions and to deal with it accordingly. The major importance of this, the creation of this authority, or the role given to it, is you have now a one-stop shop where you can check your exposure to sanctions, and you can find the local sanctions lists, which will make it much easier to different authorities and different parties to continue making the relevant checks, the relevant follow-ups to assess their exposure, to carry out their KYCs efficiently and more like professionally. Again, when we go back to your questions about the screening and the importance of screening, everybody is required to conduct these screenings regularly. Obviously, when we do screening on AML, it's different when we do screening on sanctions. Both AML and sanctions have been covered under the same laws to a large extent. Nonetheless, when you handle AML risks, it's totally different from when you handle sanctions risks. AML risks should be assessed at the beginning of the relationship and throughout the relationship. Sanctions risks should be addressed at the beginning, throughout, and at the end of the relationship. The major risk exposure is usually at the exit of the relationship, because people who have been subject to sanctions try to exit certain positions, and at that time companies or financial institutions or other parties can be at risk of being in breach of sanctions. So a lot of corporations, they do automatic screening through softwares that they buy for that purpose, and usually these softwares are efficient because it allows them to manage the screening more efficiently, swiftly, and with minimum exposure to human error, while the manual checks include a lot of like risks associated with human error. So that's why it depends on the size of the operations, on the size of client base, on the nature of the company conducting the search itself, to assess whether or not they are in need of a software, and the way to manage and regulate this software in a way that can allow them to address their relevant risks more efficiently.
Thank you so much for sharing this information. It was very insightful.